Any mention?
Please, Your Lordship.
Yes.
Sure. I'd like to mention item number 15.
15. 1 5.
Your Lordship. I'm appearing for respondent 2 and 3, Your Lordship, in this matter.
Yes.
So I'm praying if the matter can come up after a week, Your Lordship.
Who is the petitioner?
I've informed Mr. Jeshala is the counsel. I've informed the parties also.
Yes, 15. Asking for time.
No objection. After 1 week, Lordship.
Is there any use keeping it after 1 week? You'll not do after 1 week.
Your Lordship's convenience.
No, that's no convenience for me. See, whenever you are ready, it's unnecessary. Basically, thickens the order sheet. Every week you have to pass some order version. When do you want?
Lordship, after 2 weeks. After Puja will be. The only thing is that the trial is proceeding. Maybe it's the date may be
On the prayer of the respondent. This is after 2 weeks. Two weeks.
obligation.
Lordship, state respondent express.
Oh, please record.
Obligation, Lordship. Lordship, I beg to mention item 2.
2.
Lordship.
Yes. See, Mr. Monto is here after so many days.
Lordship, Lordship, now there's a new development because this matter is pertains to Shillong Cantonment Board. Now, since there's a proposal,
Proposal is there, no doubt, but the thing is, nothing has been materialized.
Settlement? Any chance of any? There is any?
I doubt I inquire from the office, maybe I think Shillong may be excluded, likely. But of course, to that effect, I don't have any written communication.
and the other matter is that, Your Lordship, the floor space index, which is under question here, that is pending consideration before the ministry. So, coupled with these two facts, Your Lordship, then perhaps.
Well, that FSR, that is pending for the whole cantonment.
No, but now because the new
What is this
because
matter?
of the new development,
This present matter concerns what?
this regarding
Unauthorized illegal
they have issued
construction.
us a notice for demolition. Now we have challenged that notice before this court. On the ground that the floor space index that is pending consideration. Now without the final consideration of that, they cannot issue the demolition.
Is beyond that prescribed.
Yeah, beyond the prescribed limit.
That is admitted by them also in the.
So you demolish it and finish the thing. So what is to be done?
Some accommodation may be granted because
Provided the other side agrees. See?
Of course, on that ground, Your Lordship, I cannot assure that with the
That
ministry.
is okay. If there is likelihood of settlement, then definitely why should this thing be? So we'll have it after.
because the other matters are adjourned for 4 weeks.
Which one?
Another matters which
The similar matters are there.
No, Lordship, concerning the Shillong Cantonment Board. Those matters are adjourned for 4 weeks. Some other matters pending before this.
Mr. Shen was there, I think, in one
No,
matter.
Mr. El Cream, Your Lordship.
Oh, no, that is with regard to the lease.
So this is not leased.
No, that's with regard to the lease.
It has nothing.
This is
No,
unauthorized
After
construction.
2 weeks, then, Your Lordship, will.
okay. Item 2.
Item 2, Lordship.
And what about 3? 3 is
Three
also,
also connected, same.
Three also is
same issue.
Suvasis is there, in fact.
You have to go to the other side, I think. It's petitioner.
Position.
Petitioner, Lordship. These are connected items.
Okay, all these 2 matters on the
weeks.
request made by the learned counsel for the petitioner. This matter after 2 weeks. You're all right.
Better, much better. Deputy Officer.
Good to see you.
Please, Your Lordship. I'd like to mention item number 7 of the hearing.
Yes.
Your Lordship, we have filed affidavit in this case, Your Lordship, and there are some minor changes which will rectify within the course of the day, Your Lordship. Let it come after 3 weeks, Your Lordship.
Affidavit. We
Yes,
filed
sir.
affidavit in respect
Bringing
of
on record the entire proceeding of the court-martial.
this is against conviction.
Yes, Your Lordship.
So it is not required that you prepare a paper book and all.
Yes, Your Lordship. We have brought
Paper
this.
book will take care of everything. Any affidavit is needed.
Your Lordship, actually, initially we didn't file that paper book. So leave was granted to us to file that paper book. So
No objection.
No objection.
Okay. On the prayer of the learned counsel for the petitioner, list this matter after 3 weeks.
oblige, Your Lordship.
Your pleasure.
Please, Your Lordship. Your Lordship, I beg to mention item number 10. Lordship, I pray for 2 weeks' time as the conducting counsel is on leave.
Item number 10.
Yes, sir.
Yes.
Objection, Lordship.
Okay. 2 weeks.
Yes,
On the request of the learned counsel for the petitioner, 10. After 2 weeks.
Highly obliged. Please, Your Lordship, I beg to mention item number 12, 13 and 14, Your Lordship. Your Lordship, I pray for 2 weeks' time as the conducting counsel is on sanctioned leave. I've already informed the other party.
Lordship, I'm for the petition.
No objection. No. All these are connected matters. 11
Yes,
to
Your
14,
Lordship.
11 to 14.
11 to 14.
Yes, Lordship.
Okay. On the prayer of the learned counsel of the respondent.
Sorry. Item number 11, I'm for the respondent. So therefore 12, 13, 14.
So you have item 11.
Item 11.
So you have objection to the prayer of this?
No.
Okay. So
They were connected matters.
yes. So item 11, you are not making any prayer for adjournment.
No. But
So 11 will remain. Her prayer is equal to 12, 13 and 14.
Lordship, if it can come up after 2.
Okay, then item 12, 13, 14 on the request of the learned counsel for the respondent.
so 11 is also connected matter.
It's okay. Then 11, you are saying that you have not adjourning.
You can take it up on the same day.
So
On the same date, Lordship.
it's item 11 on the request of the petitioner. Okay, all will be after 2 weeks. Item 11 will be on the request of the petitioner, and then 12, 13, 14 will be on the request of the respondents. Okay,
Deeply obliged.
after 2 weeks.
Complex. Good day, Lordship.
May I please, Your Lordship? I beg to mention item number 9. I pray for 3 weeks' time, Your Lordship.
I'm for the respondent, Your Lordship.
Yes. When do you want it?
After
You are for
3 weeks, Your
petitioner.
Lordship. Yes, Your Lordship.
After 2 weeks.
3 weeks, Your Lordship.
3 weeks. Okay, after 3 weeks. Item 9 on the request of the learned counsel for the petitioner. Okay.
Highly obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 6.
Item 6.
Yes, Your Lordship. Learned Counsel, Mr. Piobin is out of station, Your Lordship. Learned Counsel, Mr. Piobin is out of station.
That is a Negrim's matter. It was hard at somewhere. Okay, after 2 weeks on the prayer of the petitioner. You have no objection?
No, Lordship.
Item 6.
Highly obliged.
May I please, Your Lordship? I beg to mention item number 8.
8. Not over. The list is not exhausted till now.
I humbly pray that let this matter come off after puja, Your Lordship.
Yes, Mr. Sangupta.
No objection, my lord.
Okay, item 8. On the prayer of the appellant after 3 weeks.
3 weeks.
So bless Your Lordship.
May please, Your Lordship. Lordship, I beg to mention item number 4, Lordship. If this matter will come up after the puja application, my lord. After puja, Lordship.
Oh. No objection. These are okay. After item
Obliged.
4. After 3 weeks. After 2.
After puja, Lordship. After puja.
After 2 weeks will do, I think. Yes, after 2 weeks. on the request of the learned counsel of the petitioner.
Main list, item number 1.
Yes. Mr. Khan, see the departmental proceeding record which you have submitted, the records of inquiry officer is not there.
Lordship, this is supplementary.
Nothing is there. Please give him that. Please try to find it out. Rather, you have this thing flag marked certain pages.
This call Akin. Akin.
No, I'll bring it.
Please check your record. Please give him the record. Give him the lower court LC record. Kindly see and see your flag marking. You have flag marked all those evidences collected by in the magistrate.
Lordship, that is a separate record.
Here is only one record. Just see. Please see. That is the only LC record. Just give
another record.
Hand it over to you.
The record only contains only the whatever has been collected during the preliminary investigation, my lord, when the incident happened, my lord. That is all.
See, the court did not find the record of the inquiry officer,
my lord.
except the order and all is there. But then the proceedings, nothing is there.
No, Lordship,
I want see, like what I could gather is that you have marked those statement
those
which collected in the magistrate,
those are
handwritten things not legible. Down below, type copies are there. You have ignored all those.
All part of magistrate inquiry. The same thing happened before the other bench, and
See,
then it was directly
record of the departmental proceedings. See, we have nothing to do with.
We have given the copy, Lordship. They have a separate file. No? Mr. Lordship, the instruction that I received was that we had asked from the department. There was a direction by the court, and we had.
Record you have called for the record. Record should be here. Is it the original?
Absolutely. Only the inquiry report, Lordship. Separately we have filed.
Why? It is not a part of this thing.
No, it was not initially part of it.
Inquiry report. Copy of inquiry report is there, but then this evidence and all those things are not.
Lordship, yes, evidence we have filed.
Nothing has been collected, my lord. That is my humble suggestion. Nothing has been. There is no proper inquiry, my lord. My lord.
Yes, yes.
There is a separate record. Because Lordship, if you see the order sheet of it, we were stopped at that stage that the main record does not contain the inquiry report and the statement.
Why?
Lordship, for some reasons.
If you maintain a separate file, that is okay. But then you.
Lordship, there was a separate file on the direction of the court. The matter was adjourned, and then we had collected that copy. Let's verify, Lordship. No, the separate file.
Members, we got, I think,
Xerox copy. No, not that. The photocopy. No, it will not be part of the. No, show me not that.
Records, why photocopy? Records, you should give original, why photocopy?
Lordship, there was a problem. We requested the department, we could not get the original.
Then
but
it should be available. See, like without that, this code will not decide. Otherwise, if it is not available, then there will be.
Lordship is correct. We had received, if I may make a submission, we had received they were tracing the record because it was way back in 2009.
It's unnecessary wastage of time.
Sir, photocopies have been submitted to court master, but it's not part of this record. It was Alak sale.
My learned colleague says that was separated to the court master separately.
There is nothing in the order. If it is separated, it should be reflected in the order and all.
No, the matter did not come up, Lordship.
See,
before that, the case was transferred.
Point out two certain orders passed by this court after you submitted these things. These records. It seems this matter was heard.
Yes.
It was hearing was concluded rather, and thereafter this thing record was submitted. See, I had this code has gone through the records. We'll point out.
There is a separate file again.
Exactly, I'm just checking it. They kept it inside.
Thereafter, actually, this matter should not have been placed before this court.
Absolutely, Lordship is correct.
Only because technically it has not been kept part hard, it has come here.
What was that when it was in just Dindo's court? We have able to supply to the court master.
Who was the court master?
Dindo's court master.
Just tell. Lordship, if my
One second. Yes, 1 minute. Please check these two orders. Order dated 28/6/23 and order dated 14/7/23.
Okay. Lordship, if I may just explain what happened, was matter was concluded, and only in the issue whether the objection raised by them was whether the inquiry was not conducted. We checked the entire record, the record that was given to the court. In that record, that was missing.
The inquiry report is there, that has been annexed by them also.
Your Lordship, yes.
We want to see the records because her contention was that the inquiry is not based on any evidence.
Lordship is correct. So
that is what
that is a contention. Then, Your Lordship, we had filed. Can you, Lordship, let's just address the court on this issue.
Lordship, we had received the other reports from.
No, have you checked both the orders? 28/6 you have checked. First check it.
This one.
And come to the order dated 14/7.
Lordship is correct. Pursuant
Thereafter, check the official order sheet. Nothing on record that
nothing
there is any evidence that was submitted to the court.
Lordship is correct. Lordship,
without that, this court will not be able to decide it.
Absolutely correct. Lordship is absolutely correct. Lordship, what happened after that, when they had submitted on the next date in the court. This is the instruction I have received. Before the matter could have been taken, the matter was transferred to this court.
That's okay, but then on the day of hearing, you said that everything is there in the record and it is marked.
Lordship,
So this court went by your statement, did not even look at the record in the courtroom.
Lordship, the instruction that I received, Lordship is correct, that it was not reflected in the order sheet. The instruction that I received was that the
See your flag marking in the file. You have flag marked all those
Lordship,
statements.
those flag markings was done for the ministerial inquiry statement, not the inquiry.
So why it was done here only? This court basically was misled by that.
No, Lordship, the flag marking was only for the purpose of ministerial inquiry. Lordship was asking whether where is the ministerial inquiry.
See,
the issue is where is the ministerial inquiry order.
Basically,
that's why we have flag mark only the ministerial inquiry.
The thing was that, see, like if it is a departmental proceeding record, see, magisterial inquiry report which was relied on by the inquiry officer.
Lordship.
That is only. So magisterial inquiry is basically
We flag marked it, Lordship, only for the purpose. Lordship, we flag marked that, if I recollect, only for the purpose of informing the court the ministerial inquiry. But the other inquiry report.
Anyway, what is to be done now? Just tell us. We see what is the use of.
Absolutely. We'll just verify because the statement that.
Verify means like then what you do? This thing. Otherwise, you have to procure it and then present.
Lordship, I may admit we had received the Xerox copy of original record.
So when will produce it?
Lordship, that was be in the month of July, Lordship.
Now, what you propose to do it? If it is not there, you can check the entire sheet. If it is not there, then what is to be done?
Lordship, yes.
And here you submitted a Xerox copy. You procure the original again and then submit it.
Lordship. The original, Lordship, we could not trace from the department. That was the reason we took time. The original inquiry report, which was done in Tora, the inquiry officer died.
But nowhere it is recorded anywhere that these original records are missing.
Lordship, that stage has not come. There was some gap as I submitted, Lordship. After 14 July, when the Xerox copy of the inquiry report along with the statement was brought to the knowledge of the court, the matter could not be heard. It was transferred at that stage.
Right, but
that is the stage. That needs to be clarified. That needs to be clarified. That is the only missing link. Lordship, had the matter been taken up there, we would have made a statement. So before that stage,
verify from your side. Contact your department. If you have records, anything, produce it. If not, then we'll decide it without.
That can be done. That can be done.
When we will produce it?
When the Xerox copy is saying
within this week.
Within this week.
Within this week, I can produce the records.
Give us at least week's time. I'll have there again.
We'll release it from CAB then. Yes, no doubt. The matter was heard and kept reserved for judgment. The records of the departmental proceeding was called for, which was submitted to the court. Stop. However, the perusal of the record of the department proceeding it was found that the record of inquiry officers are not available. Stop. Mr. K. Khan, Learned AIG, praise for grant of time for placing the relevant record of the inquiry officer on record. Stop. The records of departmental proceeding which was submitted to this court is returned back so that the same can be resubmitted along with the copies of the records of the inquiry officer. Records of the proceedings of the inquiry officer.
Department proceedings,
inquiry officer in the department proceeding. See, DPC other records are your probably your appeal, the disciplinary authorities things are there.
We will confirm only to the DP proceedings.
List this matter after a week. You can procure it after a week. So you will take back the record with you. Record you are getting it back. We have recorded. We are not keeping it this record. This matter stands released from CV. The matter stands released from CV. All right.
Check it from the court master. Check it from I will.
It's a wastage of time. Basically,
apology, Lordship, because we thought the records were already in record.
So if ask the court if we can check that.
Main list, item number 1.
What is this?
Lordship, can I just take the permission of the court, Lordship, if my Lordship in this?
I don't know. Be careful in giving file and all. This is. Okay, what is the file you've given to order sheet? Is there, Alhamdulillah? Yes, Mr. Khan, what is your instruction?
Lordship, my instruction here is that on 3rd October, the government has written to the district session judge. Lordship, let me just explain. Section 24 of the CRP says the name for the PP has to be recommended by district session judge. And government does the appointment. If I, Lordship, take you to section 24 of the CRP.
Yes, then what happened? Just tell us.
The government has already written on 3rd October to the district and session judge. We are waiting. The letter says, Lordship, to enable this department to appoint a public prosecutor before the next date of hearing, so as to kindly address and suggest the name.
So, in absence of public prosecutor, what happens? All the government things comes to a halt.
Technically, it should
take arrangement. You go, you appear. We'll make some order. We'll say Mr. Khan will go and appear. So something, you see, work cannot go. You see, it cannot something like that. You see, like application has been filed, it cannot remain pending like.
Lordship, section 24 says the name for recommendation has to come from district judge.
It's all right. If you, in absence of PP, what is the solution then?
Lordship is correct. They cannot be a stopgap arrangement. But since we have shot down the letter, Lordship, hope by.
What is happening with the normal day-to-day appearings? The bail matters and all. What is happening? Who is taking up?
Absolutely, Lordship. That's the main.
Somebody is there, yes. Isn't it? So why not? Why don't you make such that kind of arrangement?
Lordship is correct. It can't. They cannot be in gap because bail matters are there. So many principal areas. Lordship is correct.
There has to be a sincere approach. You see, the casual approach will not serve the purpose.
No, Lordship, absolutely correct, Lordship. So you can say the mandate of 24, and Lordship is correct. This may be because the court has taken seize of the matter, but this should not have happened. But now, Lordship, only thing is that we are waiting. If the moment name is recommended by district judge as per section 24.
When a recommendation was made, one letter was written to this thing.
3rd October, Lordship.
3rd October. 3rd October. Until date, he has not made any.
District judges, we have not got back to the Lordship.
Who is the session judge there?
District judge, South Gara Hills.
And it's okay. Should be given priority, you see.
I think, sir, a copy was also given to the RG regarding this issue.
He should have taken a day or two only to recommend the name. Lordship is raising the larger issue. Lordship is very correct. Just because PP is not there doesn't mean the criminal justice system should come to a halt.
Yes.
Lordship, on the request of learned DSGI, Lordship, if this matter can come up at the end of the board.
Your problem is solved for today.
not. Lordship, the fact still remains that DSG is irrelevant here, Lordship. The state is under accountability to see that the PP is appointed, and we are waiting for the response from the district judge. Lordship, our situation would come if the DSG has recommended the name and we are sitting over the file. Then maybe we have a case for making an answer. But right now, Lordship.
When do you expect it will be done?
Lordship, as soon as I can give, at least I can give an assurance to the
as
court.
soon as. What is the as soon as? What is to
Then we'll take up personally, Lordship. Lordship will
week.
talk to the law secretary personally. The day recommendation comes for us is to issue a formal appointment letter.
No, if that is not done because of the session judge, then we will issue notice to session judge also. If that be the thing, if it comes to that extent.
But as I'm making my submission, Lordship, we have not received any instruction after 3rd October. This is what the letter says.
If situation comes to that, then court will have.
The copy has been given, Lordship. The copy has been given to the Registrar General, Learned Advocate General, District Magistrate, all the concerned authorities to take up the matter seriously.
If you pursue it from your office, that will be done.
Lordship will request the Lordship.
See, if you want to see, now if you, I don't think that you should basically require court to pass a harsh order.
No, absolutely, Lordship. Yes.
You can always use your office. You can use your chair and get the thing
Lordship,
done.
I'll do it. I'll speak to the Lordship.
That will be for the public interest,
Absolutely,
not particularly for this case.
But generally public interest. Absolutely, Lordship. And I can visualize the Lordship anticipatory bill matters and all the other matters without PP. And it doesn't look legally also doesn't look good, Lordship. That.
And a prayer has been made on behalf of the petitioner to adjourn the matter. Mr. K. Khan, Learned AG, appearing for the state, submits that step has been taken for appointment of public persuader.
Lordship, this is the letter of 3rd October. 3rd October, addressed to the District Session Judge, South Goa.
Can you please pass it?
Name again when you give it to the copy, court master. Let him find it out.
That is, this letter to Session Judge is 17th April 2023. See, this is written by Deputy Secretary Law, it is 17th April 2023.
I was just trying to bring to the notice after the court had seized this matter. This was the only step we had taken. We had
Imagine, and you are keeping silent. You see, 17th you have written to the session judge for recommending a name. Until now, it has not been done.
Lordship, we don't represent the session judge. So
you do not represent, but then your state.
Lordship, when the
what happens if session judge refuses to give any name?
Section 24, Lordship.
No, if there is no recommendation from session judge. No, then we have to see about that also. If that be the thing.
Lordship, will just come to 24.4. Because Lordship, the requirement of 24.4, Lordship, first has to be
This is a consultation.
Consultation.
It doesn't say that you have a recommendation. You propose the name, you consult. Why is this recommendation? It doesn't say about recommendation.
So that consultation
and recommendation is two different things. You choose me, you consult. What is the problem?
Then if Lordship and judicial order can be passed. Lordship, state power directly comes only when 4 and 5s are not complied, and then we can invoke 6. And there has to be cater for that. So we don't have that.
See, this is the duty of the district magistrate to prepare.
Absolutely.
Have you prepared a panel of name?
That is
nothing on
that
record.
Lordship, that is still pending in the state of consultation with the district judge at the stage of 4.
There has to be a preparation of panel.
Lordship. And then consultation with the district judge. Once that is done, then the matter comes back. That stage is still subject to the Lordship. Six gives power to the state, Your Lordship, again, then it reverts back to 4. So if you see 6. Otherwise, Lordship can issue direction to complete the whole process within a fixed time. If the time is given, then maybe the panel, the consultation, everything should be completed within.
My Lord, since PP has not been appointed, my Lord, and that is the reason
that is something very,
my Lord.
It's a very unusual. State is functioning without a PP, and there is a communication on 17th April of 2023, where the session judge basically was requested to recommend a name. And it seems like that has not been done. Of course, session judge, the law doesn't say that session judge will have to recommend a name.
Absolutely.
It is the district magistrate who should prepare a list in consultation.
Consultation with the district judge. The stage of consultation.
So, I do not know what is the state interest in not appointing a PP also. That is also seems very unusual.
Very unusual.
The state is sitting ideal with a PP.
Because it appears that PP is not there, even additional PP is not there. So who is conducting session trial? That is the question.
That is absolutely.
What about bail matters?
Absolutely.
I think it's
who is
day-to-day
endorsing the matters, my Lord, to APPs? But normally PP endorses the matters to APPs, my Lord. Maybe APPs are there in the district, my Lord, but PP is not there. The endorsement is.
Then how bail matters are taken up then?
I think APPs are directly appearing, my Lord.
So what is the problem? Then your matter also APPs can take care.
Because APPs in bail matters can only appear before the CJM, my Lord.
Not before session court. No. Until unless there is an adjustment.
Because certain trials are to be conducted by PPs only, my Lord. So, for example, session
trial and bail two different things.
If that be the case, Lordship can pass a judicial order. Let the PP in his so far his case is concerned can be addressed, and so far the larger issue is concerned.
If somebody is something is, say supposing if there is a provision of law, that people will not appear in this kind of cases. There is no question of court passing any orders. It will not create any other authority.
Absolutely.
Any authority other than what is created by the.
Absolutely, Lordship.
Okay, but then the thing is that concern is that why public prosecutor is not.
Lordship, a slight deviation from 24/4 also will create a new precedent. So that's why my submission was give a limited time condition and let the DM and the district session judge complete with the process and submit to the law secretary. What is required is DM to prepare the panel in consultation. A fixed time frame may be given.
What the 6 means?
6 lordships is if no suitable person is available in such cadre for such appointment. Cadre means there has to be a cadre of public prosecutors or additional public prosecutors only among the persons constituting such cadre. In other words, there should be state government should have its own cadre of PP and PP.
There nothing is.
No, lordship, absolutely not. So if there was a cadre, then straight away from the cadre they can pick and choose, and whoever is eligible can be appointed. And now if there is no cadre,
read the proviso.
Provided that with the opinion of the state government, no suitable person is available in such cadre, such appointment, the state government may appoint person as public prosecutor or public prosecutor, as the case may be, from the panels of name law, prepared by district magistrate under section 4. So again it goes back to 4. So there is no escape from 4, Your Lordship. District magistrate preparing the panel in consultation with district and session judge.
In fact, it's a matter of grave public interest.
Definitely, without public prosecutor, how can it be?
I don't know in how many districts there are no PPs.
Very surprising. From when PP is not available there?
The first letter, Your Lordship, April, there was a information given to.
Yeah, before that, there was a PP.
It seems like this after the case has been brought to the knowledge of this court and the whole issue of.
No, from when PP is absent in that area? Where the absence of PP is from when?
My Lord, this matter has been adjourned since March 2021, my Lord, for the 1-2 PP.
March 2021?
March 2021.
This matter has been adjourned.
Please take instruction from when PP is absent.
When was Bagmara separated as court? I think so.
We'll have to find out. So when was the
it must be
separation?
around that time only, my Lord.
Separation, we have to. At least we'll have to find out.
Court, there was constituted TPs.
No, Bagmara. There will be inauguration of Bagmara court in, I think, this month, 28th of this month.
For the building.
Bagmara, how they are functioning now? Is there? That is also one factor. Dr. Mujika, we do not know much.
We also don't know, Your Lordship, what is the percentage of lawyers also there.
There is no question of percentage. If you have created a separate district, then there has to be a public prosecutor.
Absolutely, that's correct. Whether you take it from Tura or from some other district, there has to be PP. And especially the session district judge is there. Without PP, it cannot function.
It is something like that.
You create a court
district was created here with only one police station in that district.
It raises a concern. Lordship is very correct. It raises a concern.
I've seen in Meghalaya.
Lordship,
you are the government. You are talking the concern. You see, you should solve it. Your solution is not in the courtroom. Your solution is in your own function.
Well, in Meghalaya, what I know is more DSPs than OCs, my Lord.
That becomes a difficult situation. I do not know. This is something.
Lordship, I'll personally talk to law secretary to this. If this is the concern.
Lordship,
will kindly appreciate our as AAG, as court officers, Lordship, we can only address the issue and inform the government.
No, you can go beyond that, and you can tell them what is the requirement.
Sometimes, Lordship, if you are fortified by a judicial order, then the order speaks for itself. Otherwise, it remains a mere opinion.
Chair is there.
Lordship, it remains in a stage of opinion. Lordship is correct. Since the matter was seized, Lordship, at least we've been instrumental in
this will not be appropriate for, you see, like AGs and AAGs, those who are representing government, to come and say that please arm us with the judicial order so we can go and implement it. It should not be your prayer.
More than persuasion, Lordship, we don't have the mandate. Lordship is aware of it. More than expressing our mind, like this is a requirement.
My Lord, as far as my interest, my Lord, if the matter may be kept pending, my Lord, to address the larger issue, my Lord. But as far as my case, if it can be transferred to Tura, my Lord, it is a matter of a short order by the session court, my Lord. PP is available in Tura, my Lord.
Can it be done?
In 482, my Lord, in my ambassador, that can be done.
482 is what?
Medicine for all disease, man.
Unfettered jurisdiction.
Well, I'll not say unfettered, my Lord, because in the facts and circumstances of the case. Because normally BSF trial, my Lord, what is happening, my Lord, the BSF unit has moved, my Lord. It is not in Meghalaya now. So many times to bring that accused person, because accused person is the BSF custody, my lord, he has to.
Now this will be transferred only for the purpose of passing order any notice.
My lord.
Now say supposing
My lord.
if your application is rejected, then for that purpose of trial it will again go back to
It
same.
will go back, my lord.
And what purpose it will serve?
Because why, my lord? It's more than 2 years now, my lord. And there is no reason that this case will not be transferred to BSF, my lord. Because the deceased is a BSF employee, and the person who shot at the accused person is also BSF employee.
No, more than that, but then if a court comes up by the end of this month, then problem will be solved. Why should we transfer it?
But this month we can wait, my lord. But
I think it is what, because so far as the information which I have, which I could get it, yes, there will be inauguration of court building in Bagwana. So there is every likelihood that court will be 28th of this month.
my lord, court is there, judge is there, my lord. So PP is not there. That is the difficulty, my lord.
Because I think this the courts are, I think, not functioning that way. You see, like.
But a proper session judge is there in Bagmara.
Once it is district is catered to, definitely.
I can wait for a month, but there is no problem, my lord. But there should be some assurance by the government that within 1 month PP will be appointed.
Lordship, that's why I was making a submission. If some judicial order is passed to consider this matter expeditious.
What do you say, Mr.? No, actually, that pair is, we forget it. The first party concern, Dr. Mujika is here. You do not say that first part is not needed. Just you say, Mr. What you say? Then thereafter, Mr. K. Khan. Public prosecutor for South Garo Hills District, and the appointment is expected to come soon. Before that 17th April 2023, there is nothing, no other thing with regard to.
This was the only instruction we received. 17 we have.
Dr. N. Majika, DHC submits that the petition filed by the Union of India was in the year 2021, and till date the same has not been taken up by the district and session judge South Garo Hills Bagmara for the reason of non-availability of the public prosecutor. Stop. It appears that the district is functioning without a public prosecutor for quite a long time, and there is no effort by the state to appoint a public prosecutor for the district. We will wait for one. These things, in view of the submission made by Mr. K. Khan, it is expected that the state will do well to appoint public prosecutor for the said district within a shortest possible time. Stop. This matter after 2 weeks.
Come up to puja vacation.
Okay, this matter after 2 weeks. Just take up your communication. Do you please, Mr. Khan?
Absolutely, Lordship.
Hearing, item number 5.
Oh, it is that matter. You have an instruction.
Matter, my lord, we are still under process, my lord. What happened? Some of the officers, concerned officers, were out of station, my lord. My lord, if 2 weeks time is granted, my lord, most probably will be resolved. My lord.
Okay. On the prayer of the, let it be after 2 weeks. It's on the prayer of the respondent. List this matter after 2 weeks. Much. That.
Yes, sir.
You will come to this thing. My room will start.